Before I start, I'd like to acknowledge the presence of the Nairobi branch council members. This is the Law Society of Kenya Nairobi branch, as well as Mr. Shadrack Wamboi, who represents Danstan Omari. So I will start by reading the statement that was issued by the Law Society of Kenya Nairobi branch yesterday, and then make a few remarks. The Law Society of Kenya Nairobi branch has received information regarding a notice issued by the Directorate of Criminal Investigation dated 21st of February 2023, served upon Advocate Danstan Omari. It is our belief that the notice is meant to intimidate, threaten, and prevent him from discharging his duties as an advocate and an officer of the court. Lawyers in Kenya have been intimidated in the recent past by external forces that attempt to limit the right to representation and expression. We are outraged and apprehensive about the environment in which Kenyan lawyers have to practice. The advocate's security is now in question, as the body which is meant to work with the lawyers in dispensation of justice is now exerting undue pressure to frustrate the existing client-advocate relationship between the said advocate and his client. The alleged offenses, as highlighted in the notice, have been used as tactics to cause the advocate to execute his duty to the client in fear and trepidation. We strongly condemn the actions taken by the DCI in attempting to curtail the advocate's freedom of expression as provided under Article 19 of the Constitution of Kenya. As per Section 134 of the Evidence Act, the DCI should respect advocate-client privilege. It is becoming common practice that lawyers in Kenya have to look over their shoulders when discharging their duties. This has to come to an end. Our fears are heightened as we reminisce the recently concluded case of the late Advocate Willie Kimani and continue to mourn the untimely deaths of our advocates like the late Jared Ratemo, the late Stephen Mburu, and the late Anthony Ngunjiri, amongst others. In light of the above circumstances, the LSK Nairobi branch strongly condemns the said actions taken by the DCI. We further demand that the government, with all relevant authorities, including the DCI, National Police, Director of Public Prosecutions, and the judiciary, take appropriate and immediate measures to protect advocates and channel efforts towards access to justice. Having said that, ladies and gentlemen, as advocates of the High Court, we are first officers of the court. It is our duty to discharge, to represent our clients faithfully, dutifully, and in the best way possible. We cannot do this if every single time we have to look over our shoulders because we are being intimidated, threatened, or harassed. And this is not an isolated incident. We have had cases in the past where we have been called to go and assist a colleague or two who, while carrying out duties attending to their clients at police stations, have been arrested, bundled up with their clients, and are in custody. We are saying the police, the DCI, and the lawyers are all working to serve the same society. So why is it that we are pulling at opposite ends? We should ideally be working together. We are in this together. It is for justice. It is to ensure that we are preserving the rule of law. And it is important that we pull together so that our society is actually receiving the best in terms of representation from the advocates and in terms of preserving the rule of law and justice. Having said that, ladies and gentlemen, thank you very much. I would now like to invite, Mr. Shadrack Wamboi, who actually represents Mr. Danstan Omari.
Notorious fact that on the 21st day of February 2023, Mr. Danstan Omari, an advocate of the High Court of Kenya, a distinguished legal practitioner, was summoned by the DCI over what was termed to be offenses that were committed on the 8th day of February 2023. You will recall that on the 8th day of February 2023, police officers had attempted, or rather, Dr. Fred Matiang'I, the former CS Interior, was apprehensive of his arrest by the police officers over alleged offenses that he was not aware of. Now, Mr. Omari, taking instructions from his client, made a press briefing indicating to the whole world over the apprehension that Mr. Fred Matiang'I, Dr. Fred Matiang'I, was feeling at that point in time. So subsequent to that, we saw this invitation. It's an illegal invitation, as we call it, where Mr. Danstan Omari was called or invited to the DCI offices to record a statement over what he witnessed or over the instruction that he received from Dr. Fred Matiang'I. Now, one of the basic principles, and this is something that we invite the DCI to also relook at, or rather seek guidance from legal officers attached to his office, is that there is a client-advocate confidentiality. And this is just synonymous to what we will have between a doctor and a patient, so that any information that comes to the knowledge of an advocate cannot be readily disclosed, and at least not without the consent of the client. So to that extent, we find that the DCI is confusing between the role of a lawyer and any allegation as far as a client is concerned. So that what we urge the DCI to be doing is to distinguish between roles of a lawyer and offenses that are committed by a client. Again, we find it to be very hostile to the oath of office that Mr. Danstan Omari took as an advocate. So much so that while he is discharging his duties and functions as a lawyer, he is summoned. Yet, on the other hand, the very client who he was representing has not been summoned. The Right Honorable Raila Amolo Odinga, who was there, who issued a press conference in tandem with what Mr. Danstan Omari issued, has not been summoned. So the DCI must, moving forward, and this is what we urge of him, he must ensure that he treats all parties equally. And as a creature of law, an office that has been created by the Constitution and the relevant statutes, he is obligated to ensure that we promote or implement that law in the manner that it is. So that moving forward, of course, we approach the High Court, the Judicial Review Division, through the orders of Honorable Justice Jairus Nga. We have stopped the implementation of those illegal summons, so that we will not be attending those summons as it was initially intended. We had initially committed to attend those summons at noon, but we are not going to honor them. This is thanks to the Solomonic wisdom and to the courage of the Honorable Court to stop those illegal summons. We'll be returning to court on the 8th day of March 2023, where the court will give us further directions. But this should be a pointer to the Honorable DCI, that moving forward, let him try and compare notes with the office, the LSK office, be it the Nairobi branch or the national office, so that he can be well advised on how to deal with matters that touch on lawyers. I think that should be all from me. I can see my seniors present. My senior Nyaberi, Samuel is here, Sam Nyaberi is here, and other members of the Law Society of Kenya. Even my senior Cliff Ombeta is also around. If they have a word, they can also share with the members of the press. This is not an attack only on Mr. Danstan Omari. This is an attack on all advocates, people who want to protect the dignity of the law. Thank you.
You take an oath. When you take an oath, you must stick by it. And what does it encompass? Also the Advocates Act. If the Advocates Act comes into play, then they will have something called privileged communication. If privileged communication is there, then there is nothing else that an advocate can do. You only stick by what your client has told you and nothing beyond that. So Mr. Omari has been called. By who? The DCI. For what? He does not know, because if you look at that summon, it has nothing clarified. Is there an accuser? He should be told about that well in advance, so that he knows why he's being summoned and for what purpose. If it is because of his calling as an advocate, then that oath and the Advocates Act has already protected him from the word go. So what does the DCI want? For him to come and say what his client told him? That one, you know, it cannot happen today or at any other time. The client also knows that whatever he has told his advocate is also privileged. So what do you do first? If you think an offense has been committed, get it done Write it down, get an OB, get a statement from the person who is complaining, inform the lawyer so that we know. These are not those days that you call somebody, bundle him and tell him, hiyo maneno utatuambia mbele. Those days are over. We know it. Even during campaigns, we say that these issues of police harassment must stop. If you are going to harass a lawyer for doing his duty, then where do you stop? Do you have a limit? If this is what is happening at this particular moment, then it shows that there is no limit. And we are going back to the days that we are saying should have been long gone. An advocate is an advocate. I remember when I was doing the Willie Kimani case, so many other lawyers disappeared from me, but I stood by my oath until the case was over. Why? Because he trusted me, he relied on me, it was his right, and I had to safeguard them. Isn't this the same case for Mr. Danstan Omari? Are you going to call him and tell him that? And you see, if you look at that summon, it has got that part that gives the penal part of it. That if you do not attend, it's an offense. The question is, which offense? I will not add anything else. Whoever might have been there on that particular day or not. He acted on instructions. He was told by his client what had happened. That is where it ends. You cannot compel him to come to you and tell you anything else beyond there. Regardless of who you are, whichever office, you cannot do so.
Now is a drawback on the progress that we have very well enjoyed with the new constitution, and we are finding ourselves in an environment where an excess in terms of executive fiat is slowly finding a normalcy. And you may remember that with the Kenya Kwanza government, when they were initially in office, there were a lot of reforms in terms of transfers within the National Police Service, and we had assumed that this would beckon some form of hope in trying to reform the National Police Service. But sadly so is that the National Police Service, and I'm not targeting anyone in blue, I can see my brother over there is getting agitated. It is a well-established principle that advocates, while discharging their functions, are protected in law and in policy. You'll find yourself in the same circumstance that Mr. Omari's client found himself in, that you are not able to find the harmony and safety in the law when the person or the agent that you are entitled to in law to protect you cannot in themselves find that protection. And so even with these summons, and as unconstitutional and illegal as they are, it is a time that both parties within the criminal justice sector need to come together and agree on a working formula, because this building that we stand behind is that anchor of hope that the rule of law will not be eroded. If we come to a point where a police officer, whether from the Directorate of Criminal Investigations or from any other agency that has criminal enforcement measures, summons an advocate or even anyone, and the summons in themselves are so compelling and so structured to say that they need your assistance in obtaining some information. And you know that this information, they're not telling you whether the information will be used against you or even ridiculously against your own client. It is in the fashion that these summons are crafted that we in fact intend to look at the whole body of the law that is framed around the issuance of those summons. I say this under my own capacity because Mr. Danstan Omari also happens to have been my teacher, and proudly so, that it is impossible, and this does not happen to Danstan Omari alone. It has happened to several advocates. It has happened to, last week there was another advocate, I just forgot his name. Yes, Velma. And there was another one, but even the law itself in this particular regime, I believe, was settled a while back in Professor Ojenda's case. But as you well know, for instance, Shadrach has just mentioned the question about the orders from the JR division. Now, sadly so, and this is the practice, and I don't know where this practice came from, that as you serve the parties involved with these orders, especially the National Police Service, this building is not very far away from wherever they come from. There is no provision in law that entitles any enforcement authority to confirm the authenticity of an order. We are finding ourselves in such a legal quagmire that we agree that this is an established norm in which we will all follow. So, for instance, when the National Police Service obtains an order against you for arrest or a custodial order, is it possible that you may pose a question and say, hold on, let us verify those orders for 14 days. So just come back after 14 days, you'll find me in my car at Java. So I am posing these scenarios just to show you the ridiculous aspect in where we find ourselves. And you see, and this is not a threat. I am not threatening anyone. Just the other day, we came from the Willie Kimani cases, just as Cliff has mentioned. And you see the relationship with the National Police Service and advocates. So isn't it a moment that we need to pull back and say, can we define the relationships and how we interact with each other? Because if you can be compelled as an advocate on services that you've discharged to attend to a private session with an officer of the DCI, I mean, it is not only appalling, it takes away the breath in me, because I have not seen this. It is quite nauseating. It is a moment where we are supposed to have a national sense of fear. And even as we address these issues within the judiciary, we also need to address them through the legislature, because most of these issues find anchorage also in law. And by challenging those specific regimes of law, we may be addressing this. And as I close, I am happy that Mr. Danstan Omari's team has been able to find some judicial protection from those summons. And I, in fact, incite presently that Mr. Omari should not have, even without those judicial review orders, attended to those summons, because manifestly they are illegal. They find no hope, and in the face of it, they defile the constitutional norm that we very well as advocates protect. I say this under my private capacity as Maura Kabata, and also as a council member.
I add one thing.
Yes.
And in order to characterize the issue, allow me to take you down the history lane. They came for Willie Kimani when he was pleading for a client, and they eventually killed him. They came for Mr. Steve Mburu. They came for Mr. Ratemo. They came for Mr. Hamlagat. And they also came for me the other day when I was representing the Mulot Sim swappers. So what we are saying is, this is not an attack against Mr. Danstan Omari. This is an attack against all the advocates of the High Court of Kenya. And as such, we wish to condemn the said atavistic and antics being instigated by the DCI. And we call upon Mr. Abdi Mohammed and Mr. Sang to resign forthwith, failure to which we shall institute mechanisms to remove them from office, because this is a clear demonstration that they are incompetent, and they have also demonstrated gross misconduct in discharge of the duties of their office. So it should be known to all that advocates should not be intimidated or should not be cowed in discharge of their mandate. We shall defend our right to practice, and we shall protect our practice environment. We also wish to remind the President of the Republic of Kenya, Dr. Samuel William, that it is through the effort of advocates that they secured your victory. Advocates, they act for all clients across the board, from Raila Odinga to Dr. Samuel and everyone. So the President of the Republic of Kenya should also do a soul searching and should know that advocates are pivotal people in the open and democratic process of the Republic of Kenya. You cannot touch an advocate. And this is an attack against all advocates, the judiciary, and the entire legal justice system. So we wish to condemn the same, and we wish to give stern warning to those atavistic primates that we shall remove them from office, and they should rescind their directive. And as such failure for them to resign, we shall institute mechanism to remove them from office. Thank you.
Well, we'll also be conducting a parallel press conference in Machakos. We have equally written to the UN rapporteur, because essentially we have the UN basic principles on the role of a lawyer, so that you cannot liken an advocate to the cause of his client. My senior, Cliff Ombeta, has over the years represented people who've been accused of murder. That does not make him a murderer. When you represent people who have been accused of anything, people who have said anything, that does not make you equal to your client. It is only that for a justice process to be efficient, people must be represented by advocates of their choice. So that if they are uncomfortable about Mr. Danstan Omari's zealous representation of people who are in one way or another likened to Azimio or One Kenya Alliance, I think they should just live with it. Mr. Danstan Omari has no apologies to make to them. And we shall continue fighting for the space of lawyers, because after all is said and done, the confidence of the Mwananchi, the confidence of the people, will ultimately be borrowed from the confidence of having lawyers who are not going to disclose anything they have been told by them after they have received some of these illegal and unconstitutional summons from Amin Mohammed and his friends. Thank you.
Right behind me, I wish to point out that we are very concerned when we see one of our own being persecuted in the limelight of the media for doing a client's task. I wish to point out that earlier on, I had been also victimized by an unhappy client who did not want me to appear for another client. And I wish to point out clearly that it was really unfair. And Mr. Omari, stand tall. We are going to defend you to the bitter cause and to the bitter end until justice is done for all advocates in Kenya. We wish to point out that an attack to one of us is an attack to all advocates who are in their course of duty. And we wish also to say that even as we continue to cry and reminisce about my former classmate, Willie Kimani, I wish to say that this issue that the DCI is raising now is an issue that lies in the courtroom. Why don't you bring the issue to the court if you have an issue with an advocate? There are institutions who are mandated to deal with any issue about an advocate. Why do you bring the issue to the media and you want to use it to attain some political or mileage or capital? We say no against such issues. We say no against such issues, and we demand an apology from whoever is doing that. Thank you.
And these, as you are aware, are issues in relation to the execution of duty by one of us, Mr. Danstan Omari. This attack is, if not condemned as we are doing it right now, is going to be an attack on all of us. Because as advocates, we swore to uphold and protect the law without fear or favor. And the Constitution allows a person who is aggrieved to be represented or to appoint an advocate of his own choice. In this instance, Dr. Matiang'I has appointed one Danstan Omari, who is a vibrant name in litigation, to represent him with a team of lawyers. Now, whatever happened between the instruction that Mr. Omari and team received is confidential and privileged. It is not available to the CID or any other arm of government to demand the instructions that presented when these advocates were being instructed. Needless to say that this is something that has come, and the sequence is a bit worrying. Remember, even when Mr. Clive Ombeta was representing the Akasha team in Mombasa, he was also a needed man in the US. And if it was not for the agitation that the team did, we could not be having Mr. Clive Ombeta around. He could have been in the US, chained and taken to the US. So this slowly is creeping into the system, and we should condemn it, as my colleagues have already done. We are condemning it, and we are condemning it to the very end. It is not available to the police officers. It is not available to the CID to ask any one of us as advocates who have received instructions to come and disclose that which we have done. Now, to make it even more mockery of the scenario is that they did a letter yesterday. You remember when this summons came, we requested that we were to get there yesterday. but because of some exigencies of work, we said we get there today. And when the Nairobi branch communicated the same, that we are going there on Monday, and actually even the national office of the LSK, they did another letter yesterday demanding that Mr. Omari presents himself at the DCI, not as an advocate, but as an individual who is a person of interest in terms of the recent happenings at the Dr. Matiang'I's place. So where does that line cross? Where does the line of being an advocate and going as at a personal capacity present? So these are some of the issues that we presented to the court, and we are glad to inform the country that we have gotten a shield from the court by way of issuance of those orders, and we will be informing you in due course the next course of action. We have engaged with the national office, we've engaged with the Nairobi branch office, and actually we want even to agitate that a time comes when all the advocates in the country are going to down their tools to condemn this particular act that has been emanated from the office of the DCI. So I urge my fellow colleagues to stay strong. Let's soldier on. The turbulence are there, but we shall overcome. Thank you so much, and may God bless you.